Hello and welcome to the program. I'm Millicent Walker. On this episode of Law Weekly, I'm on a mission to find out what happens next to the recommendations of the different panels of inquiry across the country. I speak to a senior advocate of Nigeria, Dr. Remi Olatubora, former Commissioner for Education and former Attorney General and Commissioner for Justice, Ondo State. According to him, inquiry reports are only investigatory and recommendatory, as they are not admissible in a court of law. He also speaks on other issues such as the direct primaries in the Electoral Act Amendment Bill. This is followed by a report on the Judges' Conference which took place in Abuja, and another report on the latest on the siege at Justice Odili's home from the House of Representatives and the special investigation by the Nigerian Bar Association. What is the duty of a panel of inquiry? What happens to the recommendations? And what is Nigeria's history of white papers from past panels of inquiry? In this interview, Principal Counsel of Remi Olatubora and Company starts by explaining the rules that apply in a panel of inquiry from that of a regular court.
The duty of the inquiry is to look at the truth of what happened. How did it happen? And then, of course, what are the recommendations that we are likely going to make to avoid such situation in the future? I expect that the committee report, the inquiry report of Lagos will contain the truth of exactly what happened, when it happened, and how it happened. And I feel that having had the courage to set up the inquiry in the first instance, the government of Lagos State would also be ready to also make the report of the inquiry public.
Especially the events of the Lekki Toll incident.
Yes, it was a disaster. And we must have a historical record of that disaster, so that revisionists will not come in future to tell us a story that is different from what exactly happened.
So if we have, and this is assuming that we have a report that indicts the government, in this case the federal government, what action do you expect the federal government would take?
Well, you see, we have to also know the limits of inquiry reports. Inquiries are investigatory and then, of course, recommendatory. Unlike a regular court can make definitive position. The regular court's responsibility is to know what happened, how it happened, who is liable, and then, of course, the penalty. But inquiry is very unlike the regular court. It would give you the report of what happened, how it happened, and what to be done to avert reoccurrence. Inquiry report also would identify those who are responsible. But inquiries have no power to make definitive determination.
Not to mention penalty.
Oh, yes.
What if the inquiry didn't address everyone's concern? What if there are still some people that, they hadn't concluded their case? What happens to them, especially if they want to take the matter to court? Are you saying they don't have that opportunity now? Since
they do. Even where an inquiry report has been rendered, if you feel that the report of the inquiry is not satisfactory enough, in the sense that the inquiry has not brought out exactly what happened, you can go to court.
But what evidence do you bring before the law court?
Oh, a lot of evidence.
The evidence has been used under the inquiry.
You will not be coming from the point of inquiry report. There was no evidence that was given in inquiry, particularly those who are in the virtual presentation, like video recording and all of this, that are not still available. There are people who are there when this event occurred. They are still alive. There are those who witnessed the shooting of some individuals who are very well known to them, and they are still alive. They can still be called to court to give evidence in the law court in support of whatever claim that you have before the court.
Looking at the panel and how it all started, ENDSARS, an end to the SARS squad, and then the good governance and the unfortunate incident of the Lekki tour in Lagos. Do you think that the panel of inquiries, and this is across the country, met the objectives at the end of the day?
Unfortunately, the only one that we have seen with so much seriousness and publicity is the Lagos inquiry. The Lagos inquiry is in the news at all times. When the report was presented to the governor, it was in the news. I have not heard any news about all other inquiries on the ENDSARS protest. I'm not saying they don't exist, but I have no information about them.
Do you think the people will be satisfied at the end of the day with the decisions of either the government, state government, or the federal government?
I think the people should be satisfied, particularly in Lagos State. The government has been very proactive, but that is also understandably so, because much of the destruction that came in the wake of the ENDSARS crisis happened in Lagos.
Historically, what has happened to white papers of previous panels?
Well, that is a story for the government that they will have to tell us in future, if not now. I've also been involved in a number of such interventions. For example, I was in the 2014 confab. The confab also was like an inquiry, even though it was not actually set up under the Tribunal of Inquiry Act, but it was an inquiry. What exactly is happening? Why are there so much dissonance between what the provision of our Constitution and then the desire of our people? We were there in Abuja for 6 months. So much recommendations were made. Electoral reform, all of this, the National Assembly is now attending to, were part of the report that was made in 2014. I served in the Committee on Electoral Reform, and I recall that we invited the chairman then of INEC, Professor Atahiru Jega. He didn't come in person, but he sent the most powerful delegation that can ever represent that commission to present for us what looked like a PhD thesis of possible electoral reform going forward that the country should embark upon. And between 2014 and now, we are still running on the same cycle. There's nothing that the National Assembly is talking about now. Electronic transmission of results, electronic voting, how to ensure the integrity of the electoral process that was not in the thesis by the delegation sent by Professor Atahiru Jega.
But this also doesn't mean that we shouldn't adopt some of these inquiries or implement them. And this is to forestall what the inquiries were meant to solve.
Yes, I think going forward, the inquiry law itself needs to be looked into. There's a need for reformation. Now, inquiry reports is not going to be admissible in evidence. Should we continue with that? There's no doubt that the reason why that law is made like that is to enable people to come out clean during inquiries, to be without any fear of likely use of the evidence given before the commission in subsequent judicial proceedings, either against their own interest or against the interest of somebody else. So I think the purpose of that particular provision, but should we continue with it? Shouldn't we be able to weigh the advantage to be gained if that particular section is taken out from the principle or for which that particular provision stands for as the law is at the moment. So I think one other aspect that we should also look into is that should we continue to make inquiries investigatory and recommendatory? Shouldn't we also give inquiry reports some level of definitiveness that you give to judicial decisions? All of these are what some other countries are looking into. And some have gone some way in effecting some amendments.
And for this to happen, we'll need the legislature.
Oh, yes.
Is the Constitution still the problem, as opined by some senior lawyers?
Yes. The Constitution of the Federal Republic of Nigeria as it is today cannot take us to anywhere. Take that from me.
But the 2014 confab was by another administration, another political party. This is another administration, a different political party altogether. Do you expect that they would adopt that confab or have a new one?
I expect that they should look at those reports and look at those recommendations and take as much as they can take. Government is a continuum. It's not about political party. In developed democracies of this world, you don't have a government coming in, abandoning the project that the previous government left uncompleted. It will never happen in the United Kingdom. It will never happen in the US. It will never happen in any of those developed democracies. But it's only in Africa that you find a government coming in and then abandon. Sometimes they do it with so much bitterness that uncompleted bridge will be left undone because it was initiated by the government that came before. It is never done. Government is a continuum.
Let me ask my final question, and that is on direct and indirect primaries. Well, we know what the National Assembly has done recently, and there have been a lot of talk. A lot of people are not comfortable with direct primaries. What's your take?
Well, let me first and foremost congratulate the leadership of the National Assembly. For the first time in the recent history of the National Assembly, they have done what is very, very honorable. You know what they did? They took power from the political elites and give to the people. And that is all what democracy is all about. That singular intervention is a way of giving back, taking back from a clannish political elite to the people. And that is what democracy is all about. So it is a recommendation that we must celebrate. It is a revolutionary recommendation. And when you complement that with electronic transmission of results, electronic voting, which I know by the grace of God will finally come on board, you will have succeeded in giving power to the people, taking it from a cabal of very tiny political elites that have held this country in the jugular for so long a time that the country is now reeling in pains. You will have given it back to the people. Let the people choose who is to be their leader.
Meanwhile, here's a look at the 2021 Biennial All Nigeria Judges Conference, where Vice President Professor Yemi Osinbajo, representing President Buhari, reassures of his administration's support to the judiciary.
Thank you very much.
The All Nigeria Judges Conference held this week in Abuja, with the Vice President Professor Yemi Osinbajo representing President Muhammadu Buhari. Also in attendance were Tanko Mohammed, Chief Justice of Nigeria, Justice Mary Odili, other justices of the Supreme Court, heads of court, Honorable Onofiok Luke, lawmaker representing Etinan Nsidibium in Akwa Ibom, represented Right Honorable Femi Gbajabiamila, Speaker of the House of Representatives, with other delegates in attendance.
But I must not forget to mention
Speaking at the conference in a message passed by the Vice President, who is also a senior advocate of Nigeria, the President assured the judges of his administration's continuous support for the judiciary.
As my lords are aware, delay in the dispensation of justice, coupled with the increase in the number of cases in our courts, have remained subjects of grave concern. As someone said, our problem is not access to justice, it is exiting the justice system. And I know that delays are not necessarily the fault of judges. Lawyers are often also responsible. Should we not then, as has been suggested by some, be evolving a cost award system that recognizes the court as a finite and expensive public resource, and as such, delays and other dilatory tactics are visited with deterrent costs.
Then the Chief Justice of Nigeria addresses the participants and places the complaints of the judiciary before the Vice President. The CJN also has a message for the governors of the Federation, ensuring that provisions of Section 121 Sub 3, which provides any amount standing to the credit of the judiciary in Consolidated Revenue Fund of the state shall be paid directly to the heads of courts concerned, is fully adhered to and implemented on judicial independence. Justice Mohammed also highlighted tackling the issue of corruption within the system, which will continue to be on the front burner.
And should not be seen begging. Please give us what is due to us. Now, I urge the state governors to emulate the federal government by ensuring that the provision of Section 121, subsection 3 of the Constitution is fully adhered to and implemented. I also urge the governors of all the states of the Federation to remember that the judiciary cannot be regarded as being independent unless it can adequately, underline the word adequately, meet its needs without bowing to the pressure of those that it be.
The Vice President further lists some of the measures being taken in the administration of justice system.
Up next is the Nigerian Bar Association's special investigation into the unlawful invasion of the premises of Honorable Justice Mary Odili on Friday, the 29th of October 2021, and the efforts of the House of Representatives to prevent a recurrence.
I don't think that it would be out of place for the federal government to have...
Staying with the latest surrounding the investigations into the siege at Justice Odili's home, the House of Representatives Committee on Judiciary is canvassing adequate security for judicial officers to avoid a repeat of the siege on the residence of a Supreme Court Justice. The chairman of a committee, Onofia Luke, stated this during the budget defense session of the National Judicial Council. The committee is concerned that actions such as that could weaken the morale of judicial officers.
We should create an enabling environment, not only the working environment, not only a good living condition, but a secured environment for our judicial officers to operate without let or hindrance, without any fear of intimidation or harassment. That is why we want to use the opportunity and condemn the attack and on the Justice Honorable Justice Mary Odili, the Justice of the Supreme Court. And then we ask that this should not repeat itself. It happened in 2018, I think 2017 too. This should not be allowed to repeat itself because we are weakening the morale and the strength of our judicial officers.
And that's the NJC.
In the meantime, while the Nigerian Bar Association at a press briefing on Friday, November the 5th, named Mr. Mandil Bani as a chairman of its investigative panel on the issue, given a 2-week period to carry out its investigations, so far, the special investigator, Mr. Ubani, says they are making progress with the investigation, noting that the NBA may have to extend its timeline within which the special investigator will be required to turn in its report, as there are many fields to cover.
So is it right for AGF or any arm of government to go into the home of a judge without any proper description of what we are going to go and investigate?
Meanwhile, in a recent statement, the NBA distanced itself from disparaging remarks against the person of the Attorney General of the Federation and Minister of Justice, Abubakar Malami, on social media. Part of the statement from the leadership of the NBA says, "It is highly mischievous," the statement making the rounds, credited to the president of the NBA, some of which reads in part, "Abubakar Malami is the most incompetent Attorney General of the Federation Nigeria ever had, a lawyer with no respect nor regard for rule of law." Malami cannot deny being involved in a raid of the House of Honorable Justice Mary Odili. He is a principal suspect here, and the earlier he admits the fact, the better for him. No Attorney General of the Federation has divided this country like the way Malami did. Malami is not only tribalistic in nature, but equally lacks moral principles and character. Rejecting those comments, the leadership of the NBA states that it has since set up a machinery to investigate the matter of the invasion of the home of Justice Odili. The aim of the said investigation is to provide the NBA with credible information based on empirical data regarding the raid on the home of Honorable Justice Mary Odili, JSC, and will not make comments that risks jeopardizing the process. What is more, the NBA has its official and dedicated communication channels and does not make statements through proxies or fifth columnists. The NBA says it remains resolute in its determination to fish out and bring to book those who raided and or authorized the raid on Honorable Justice Mary Odili's house, in line with its mandate of promoting the rule of law and defending the independence of the judiciary.
And now to some of the cases that kept the courtrooms busy.
We begin with the trial of Chidinma Ojukwu, accused of murdering Super TV CEO Usifo Taga, as cross-examination of a prosecution witness continued by the first and second defendants' counsel. Abubakar Muhammad, a security guard at the service apartment where Taga was murdered, maintained his earlier testimony that the defendant left the apartment a night before the victim's body was found. Muhammad told the court that he did not get the full view of the victim when he came into the premises because the victim was inside his vehicle. At the end of the cross-examinations, Justice Yetunde Adesoya adjourned the case until November the 25th for continuation of trial. Staying in Lagos, this time before Justice C.A. Balogun of the Lagos High Court in Ikeja, the trial of Abubakar Peters and his company, Nadabo Energy Limited, over an alleged 1.4 billion naira all-subsidy fraud, resumed, and the case started with the judge informing the counsels that he would like to complete the case this year, therefore both parties should organize themselves. Afterwards, the fifth prosecution witness, the EFCC chairman, Abdulrasheed Bawa, continued his account of the investigations, which he claims were contrary to the claim of the defendant on a number of issues. According to Mr. Bawa, when the Commission put an investigation activities letter to the Petroleum Products Pricing Regulatory Agency, they responded, giving them their findings and requiring them to recompute the subsidy that ought to have been paid to the defendant based on their findings.
We are here because we believed, based on our findings, that the defendants only imported 6 million liters, and they are claiming to have imported 19 million liters of PMS. And the government, overpaid them with over 900 million, and that is why we are here. That is the theory of our case.
But that's our program today. Don't forget that you can catch this episode of the program and past episodes on our YouTube channel. I'm Millicent Walker. Thank you for watching. Stay safe.